Hi everyone. Today we have Professor Anita Allen with us. She is the Henry R. Silverman Professor of Law and Philosophy at the University of Pennsylvania and also this year's Hart Fellow at University College. And she'll be presenting a paper that she's worked on with Jennifer Rockman titled Postmortem Privacy. As usual, the format will be 30 to 45 minutes of Professor Anita's presentation, and then we'll open up to Q&A. Thank you.
Thank you. Thank you so much. It's a great pleasure to be here with the Oxford Jurisprudence Workshop to talk about this paper in progress. The paper is, as some of us have noted, very long. It's a paper that's slated to be published in the University of Michigan Law Review in the fall, and so the paper will be coming out relatively soon. But the great thing is that what you say to me today will be helpful for the revisions of the paper that are ongoing through the editing process. Postmortem privacy might seem like a very obscure, impractical topic, but I think that by the end of the paper, if you had a chance to read it, or by the end of the presentation, you'll understand why we think this is a really important topic affecting all of us every day throughout the world. So there is in American law a very old doctrine which says that the dead cannot have privacy rights. And thinking about the source of this rule, it's important to keep in mind that U.S. privacy law and U.S. law in general has sort of three different faces. There's the common law, which is the judge-made law, which we largely inherited from England. And then there's the statutory law, which states and the federal government can enact. And then there's constitutional law based on the constitution of the states and also the constitution of the federal government. So we talk about a legal doctrine. I want you to understand that in the initial frame of this paper, we're noting that it's the common law, that first area of law, in which this doctrine arose that says the dead can't have privacy rights. And the rationale for the argument that the dead can't have privacy rights is interesting. What lawyers and judges have been saying since the beginning of privacy rights in the late 19th century, early 20th century, is that the dead lack feelings and sensibilities. So how can they have privacy rights? They also say that privacy rights as a type of right is a personal right, and therefore it can't be asserted or waived by other people. If it can't be asserted or waived by other people, it can't be attributed to the dead, who of course have no ability to act. So for those two reasons, the courts have been extremely hostile to the idea that the dead have privacy rights. But alongside of the legal doctrines, there's a whole world of philosophy, moral philosophy, in which the moral philosophers have also been debating the question of whether the dead have privacy rights or the dead can have rights in general. And the philosophers often say the dead can't be harmed, the dead don't have any interests, the dead can't have any rights. If you can't have be harmed, you can't be benefited or harmed, you can't have any interest, you can't have any rights, then you can't have a right to privacy. And so if you put together the philosophical literature, which is largely, I'm going to say largely against the idea of ascribing rights to the dead, combine that with the legal argument that no sensibilities, no feelings, no rights are personal, especially privacy rights, then you have a sort of powerful intellectual apparatus that seems to support the idea that there aren't privacy rights. But it's a good time to revisit the claim that privacy rights terminate with a person's death. And there are five major reasons for this. First of all, today, as you know, the deceased leave behind much digital data, including social media posts and emails. A treasure trove of information is left behind today when we die. We used to live behind maybe a diary, maybe some letters. Today, it's all of that, plus all the online stuff that we leave behind. A second reason for really focusing on this postmortem issue is that the circulation of images of the dead have begun to generate a lot of controversy. And the example that we like to use in the US is the example of the basketball player Kobe Bryant, who was killed along with his daughter and a few other people in a helicopter accident a couple of years ago. Well, when he died, the first responders, the firefighters and the police and the state troopers descend upon the crash scene, and some of these people take photographs of the mangled helicopter and the body parts and so forth, and they decide to, for non-professional reasons, to circulate these images online. Well, when the widow, Mrs. Bryant, found out about this, she brought a lawsuit against the Los Angeles public authorities for whom these folks worked. And she actually won a $30 million lawsuit. Um, I think they settled for $30 million because of these crash scene photographs being shown of this dead celebrity. Third reason we need to pay attention to this issue today has to do with the possible reanimation nowadays of dead celebrities and public figures and even ordinary people. One interesting example of reanimation occurred in the US just this year when um, children who had been killed in some of our horrific school shootings, their voices were reanimated and they were then presented in Congress arguing, pleading for gun control. Um, the parents of the children cooperated with this, but I thought it was of some concern whether or not it was right for dead children, deceased children, to be reanimated to join in a political debate, even one that I think is on the right side. They were on the right side of. Fourth reason, big business in interactive wills, holograms, AI conversations with the dead. People want to talk to their dead loved ones. And AI can help you to have a conversation with your dead grandmother or your dead spouse or your dead child or your dead parent. And I think this is only going to become a more increasingly common phenomenon that people are uh, reanimated to read their own wills, reanimated to interact with people on a daily basis. How was your day? Was it a nice day? And so forth. And then finally, there's a growing interest in um, doing better justice to groups whose remains have been mistreated in the past, such as Native Americans who, were committed against whom genocide was committed in the United States in the late 19th century, 18th century as well, and many museums and collectors have skulls and other sensitive items that belong to deceased Native Americans, and there's now a federal statute which gives Native Americans the right to exercise some degree of control over these remains and to properly bury them sometimes after centuries or more of being outside of the control of the tribe. Same thing with African Americans. There are now many uncovered African American cemeteries where enslaved people were laid to rest, or just poor people were laid to rest. And now there are some laws in place that are aimed at giving some control or some rights to African Americans to determine what happens to the remains of their people. So it is a good time, I think, to revisit the claim that privacy rights terminate with a person's death. And I'm not going to be arguing that all the rights at issue in this context are privacy rights, but this paper does focus on whether the discourse of privacy has an important role to play in how we think about the postmortem rights. So the aim of our project is to address the confusion and disagreement over whether and when and how the law should extend privacy rights, but also to provide some guidance for how the law should address concerns over privacy rights for the dead and their living relations. My co-author, Jennifer Rothman, is a professor also at the University of Pennsylvania. We're colleagues there. Her background is primarily intellectual property law and the right of publicity. My background is mainly privacy and data protection law, and we believed that because this issue implicates both intellectual property and privacy, especially when it comes to publicity rights, that we were a good team to work together on this project. So the first part of the paper we describe as mapping privacy for the dead, and here is pretty much the descriptive part of the paper, where we're just saying, although there's this common law doctrine that there's no privacy for the dead, look at how many areas of American law, some of which are similar to laws of other countries, where we do recognize privacy rights for the dead. So we could have mapped these rights. And we talk about privacy and publicity torts. We talk about rights under education law and health law, about rights under census, tax, and data protection laws more generally. A couple of examples. So one area that we map are the laws of against intrusion upon seclusion and publication of private facts, and we talk about funerals, dead bodies, autopsy photographs, death scene and death images photographs. And it turns out that one of the areas where the courts are most likely to recognize that there are interests and rights of the dead is in connection with death scene and death images. And if they don't recognize rights in the dead person themselves, they recognize rights in the family members, such as Kobe Bryant's wife, to recover for non-authorized use of such images. Um, Other area, appropriation of name, likeness, identity for commercial purposes. These rights are often limited to people who have died with commercial value, but it's interesting how these rights do not go away with death. They extend for 10 years or 20 years or 40 years or 100 years or sometimes even into perpetuity. So what's fascinating to us is that this doctrine that there's no privacy rights has withstood time, even though one can cite numerous examples within American law itself of this not being a true proposition. One of my favorite examples of this is our data protection law affecting health records. HIPAA is the nickname for our federal medical privacy law. It's called the Health Insurance Portability and Accountability Act, and it covers both the cybersecurity and the data protection aspects of privacy aspects of health records. And under this law, a person's health records remain private for 50 years after the person has died. Clearly a post-mortem privacy right that belongs to the individual. Yet it said no privacy rights for the dead. It's not true. What about census data? We have a decennial census in the United States. Every 10 years, there's a count of all people residing in the United States. It's used to help apportion senators and representatives to Congress, representatives mostly, because we all get 2 senators, but different representatives numbers based on how many people live in our state. So that data is very sensitive because they collect not only just your name and where you live, but also they can collect your income and who lives in your household with you and some other sensitive matters. So this census data, it's private for 72 years after collection. Well, that's a post-mortem privacy right. So part 1 of the paper is just chronicling these different areas of law, common law, statutory law, different types of statutory law, in which it turns out that people do have an interest in privacy that's protected after they die. We also have examples in the paper of where there isn't such a right, right? So that we're not saying that in every case there's postmortem privacy. What we're saying, though, is that it's a mixed picture, and it's a confusing picture. Why 72 years over here and 50 years over there? Why 72 and not 75 or 73? So there's some randomness to these laws that we're trying to make sense of, and I think that the paper makes some progress in that direction. So that's part 1. Part 2 of the paper we called identifying postmortem interests. And this part of the paper is the most philosophical. So after we do the mapping, we then try to analyze the reasons that there might be to extend rights to some forms of postmortem privacy. And we stress that the living have interest in the treatment of their future deceased selves, and that there's also an interest in how we are treated and how those left behind are treated in relation to us. So that's the general direction, an interest analysis of the deceased, of the future deceased, of the relational living, and of society in general. But before we kind of dive into the legal analysis of interest, we pause to flag fundamental concerns arising out of moral and legal philosophy that relate to our topic. And here we refer to the jurisprudence of exclusion. The jurisprudence of exclusion, as we characterize it, is the area of law, a legal theory, that inquires about by virtue of what an entity can be ascribed rights or certain rights. And so in this area of jurisprudence, they're often paradigm cases. So the paradigm case of a entity with a right is a fully formed adult human being, but that leaves unclear the status of trees and fishes and embryos and corpses. So the jurisprudence of exclusion may bear on whether or not it makes sense to ascribe privacy rights to corpses, to the deceased. Um, Other examples of sort of paradigm right holders would be sort of paradigm privacy right holders are certainly again full-fledged, uh, non-comatose, non-demented adult human beings. But again, what about other types of entities? Are they also going to be privacy right holders? What about corporations? Are they outside the bounds of privacy right holders? Who can be benefited, who can be harmed, who can have interest. So all these philosophical questions, and I love your feedback about some of these issues especially. Um, all these philosophical issues are in the background. What we do is we don't try to resolve all the issues of the jurisprudence of exclusion or the underlying moral philosophical questions about interest and rights and welfare and well-being. What we do is we flag the issues and say, okay, we're going to assume that that the dead, or at least the living in relation to the dead, or at least the future dead, have interests which the law can base rights on and enforce those rights. And in trying to make this leap from not leap from, but leap across philosophy and jurisprudence into positive law, we are mindful that we're probably assuming a theory of rights which is closer to what some philosophers might call an interest theory than a will theory. So interest theories ascribe rights based on whether entities have interests that the law could protect. And those interests could include interests that belong to entities that don't have moral autonomy, whereas will theories of rights ascribe rights where the right holder has preferences to protect or are capable of exercising rights or waiving the rights. And in that case, the theory kind of excludes from rights ascription possibility entities that lack moral autonomy. So we're probably presupposing an interest theory of rights, both as a matter of jurisprudence and as a matter of philosophy. So in this second part of the paper, we do distinguish between several different categories of interest holders, and we use some funny language. We have to coin some language. First of all, we talk about decedents, which is not a funny language; that's standard English language. But we're reluctant to ascribe rights to the dead qua dead, and part of that is because we don't want to get tangled up into the metaphysics of death and the afterlife. Um, and also because you quickly raise questions about confront questions about who can exercise the rights of the dead if they have quad dead rights. Instead, we think that a more logical and more practical category of interest holders would be the future decedents, and you and I are all future decedents, future dead people. And while we're alive, we have interest in dignity and autonomy, and we have responsibilities, and we have the capability to be incented, and we have goals of wealth accumulation, all of which can support particular directions in the ascription of privacy rights post-mortem. Some philosophers use the expression, not future decedents, but the expression ante-mortem persons. Before I ever saw the word ante-mortem, we had already coined future decedents, so we kept future decedents in our paper. But then we have another term we call the relational living. And the relational living are the people who may be kin to in some way or associated with in some way the living, who have an interest in what happens to living when they die. So obviously our families, maybe our close friends, maybe even some business entities to whom we sell or lease our rights might be relational livings. But we do think that there's a justice and a practicality to ascribing rights to the relational living. Especially we argue rights around the grieving process and protection of memory and reputation. And then we think society itself has some interest in what happens to the dead. And so respect for the dead, respect for the burial processes, may be societal interest, not just the interest of the relational living or the future decedent. And we think that protection of society from society's norms has some value, and that's some legitimate value, and that maybe one of the goals of postmortem rights could be to protect the interests that society might have in well-being. And then the last part of the paper we called contours and boundaries, and we argue that, well, if you buy into the notion we argue for in part two, that there are postmortem rights based on interests, then we do have to think about, well, what about when these kinds of interests clash, conflict? What about the boundaries on those kinds of interests? Can it be absolute or not, or why not? And so part three just deals with contours and boundaries. So one type of contour and boundary that we worry a lot about is boundaries around eligibility and standing, like who can have these rights, and who has standing to assert these rights. In terms of eligibility, some of our American jurisdictions want to ascribe postmortem rights primarily to rich people who have already invested in their identities before they die, and therefore they have a property interest that their heirs and successors and interests can benefit from. But we try to argue that rich and poor alike should have postmortem rights, not just the rich or the famous. Issues of standing are incredibly important in this area, because not everybody who might be, say, a family member or a friend will have good enough knowledge, close enough knowledge of the deceased in order to accurately or properly represent their interests. In this regard, we cite a very old case as a starting point, from the 19th century, in which a woman, um, a wealthy woman, had been very active in feminist causes, women's suffrage and feminist causes, getting women educated and supporting women's rights. Well, when she passed away, a group of her supporters wanted to erect a bust in her honor, at a World's Fair in Chicago, and her family members, especially her son-in-law, who was also her nephew. People had, nephew, son-in-law. You could marry your cousin in those days. Um, uh, he objected on the grounds that, oh, she was a retiring, modest woman who would never want to be out there in the public sphere. But he didn't know her, and he didn't approve of her being a feminist, and so he didn't want this bust erected in her honor. So you have a clash between the understanding of her that her feminist friends had, and the understanding that her family had of her, and that was a huge clash. It was unseemly in some ways in the late 19th century for rich white women to be acting living actively in the public realm, and so the case reflects that tension. We argue that even today this kind of thing can happen. After you die, perhaps your family doesn't want it to be known that you were gay, or that you were um, uh, involved in supporting gay rights or trans rights, for example, or feminist causes for that matter, and may try to suppress aspects of you that are in fact you. And so this issue about boundary drawing and standing has to confront the issue of who has a right to assert the personality interests or the publicity interests and rights of the deceased. It's not clear that it's just the family that might have those concerns. One interesting question that gets raised in this context also is commodity racism, which is the idea that uh, goods can be sold, maybe even people can be sold, um, to make money based on racist premises. And one of the fears that I had going into this project was that we might discover that maybe Black people were more likely to be exploited and abused after death than white people. But I'm glad to report that that seems not to be true, at least when it comes to the entertainment industry and the sports industries, because people like Michael Jackson or Whitney Houston or even Prince, they in death have a lot of control over their estates. I'm talking about Prince in just a second, but a lot of control over their resources and the right, the quote unquote right people, the family, get the benefit of their fame. But but it's not true across the board. So Prince is actually a counterexample, because when he died, he had a whole collection of music that he didn't want to be revealed to the public. It was private stuff. He hadn't published it, released it, and yet his next of kin, who were not close to him in reality, didn't he was not they were not close, emotionally close to him. They are now able to capitalize on this corpus of work against the wishes of Prince, and that seems a little a little wacky. Martin Luther King was another example of someone who um, I would say belongs to all of us, like Gandhi or or Princess Diana. But his family is still exercising tight control over his image. His sons were paid $800,000 a statue was erected in King's honor on the mall in Washington D.C. It's like, what, Yes, and they have allowed his image to be used in commercials for trucks. I mean, so the daughter and the widow were rather protective of King's image, but the sons, through their foundation, have been remarkably willing to capitalize on the personality attributes of their deceased famous father. So I have not seen much evidence that Black people do worse off, do less well when they die. Uh, but here's some things to think about. So um, remember, I think it's now 4 years ago that George Floyd was murdered. He was the Black man who the police were trying to arrest because he'd been allegedly trying to pass a fake $20 bill, and the police officer who was mostly in charge of the arrest put his knee on his neck, and he was killed, murdered. So who owns the images? How do we think about the control over the images of his death? People with cell phones filmed the killing, filmed the murder, and that's a good thing, because I think we all needed to know the extent to which race still plays a role in police misconduct. But on the other hand, wouldn't it be shocking and unseemly if a company like Gucci or Burberry decided to make fancy T-shirts that were sold for $1,000 each with the image of George Floyd, on them? That would be very unseemly. But what's to stop that kind of thing from happening? Does the family have a right to control the image of George Floyd's in general, even if they don't have control over the videos that were taken at the moment of his death, that were widely publicized? So anyway, so I think commodity racism is an interesting concept to explore. It does not turn out in any simplistic way that Black people do worse off than white people when it comes to publicity rights, but I think there's a lot to think about and talk about there. Finally, duration. We do think that one interesting and hard question is, how long should publicity rights last? Should they last, and how do we decide how long they last? And so we come up with a little schema in which there's sort of three possible ways to approach this. We call them durational idealism, durational generationalism, and durational pragmatism. Idealism would attempt to find some ideal perspective, some ideal perhaps philosophical perspective, like dignity, from which we could infer whether a person should have a right for 20 years or 30 years or 50 years or 100 years or in perpetuity. But we don't find that idea particularly appealing, in part because of the huge amount of disagreement about what ideals would govern such determinations. Generationalism would sort of say, well, let's just protect postmodern rights for a couple of generations or one generation. But then the question arises, what's a generation? I find that some of my younger colleagues think that 20 years is a generation. I think that like maybe 70 years is a generation. But anyway, defining generations. Gen X, millennial. I mean, what kinds of concepts do we use to define generations? I think ultimately that maybe a pragmatic approach ought to apply, and we do in the paper elaborate what it would mean to think pragmatically about how long postmortem rights should last. And then we do worry about limitations on grieving, public grieving. Um, there are those who think that one of the main reasons for postmortem rights, and I think we probably come into this category, had to do with public grieving, like the you need to give people the space to grieve privately and publicly, but yet we don't want to say you can never talk about uh, um, um, uh, um, or publicize aspects of a person because of the grieving process. And there's interesting literature in the medical field about what counts as a reasonable period to grieve, and it's mostly literature about private grieving. But they're saying 1 year, and beyond that, it's pathological. So what does that imply about how long postmortem rights should last? So those are the three parts of the paper, and there's so many interesting cases, individual cases that I would love to talk about as a way to sort of tease out intuitions about postmortem rights. And I can just give you two quick examples because I think it might be helpful for the discussion. So I mentioned earlier that images of the deceased are a sensitive area where the courts do tend to recognize some sort of interest, mostly in the relational living, to limit the publication of these kinds of representations of deceased persons. And one of my favorite cases, because it's so bizarre but recent, is a case in which a woman went to the hospital, pregnant woman. She had a stillborn infant, and when she was well enough, she went home. And a couple of weeks later, she opens her mail, her postal mail, and there's a photograph of the stillborn infant, but it's been posed in a lifelike position, and little angel wings attached to it. And the people who sent her this photograph, they thought they were doing something very kind, to sort of glorify and celebrate the short life of this little baby, now an angel, so to speak. But she was horrified. The woman was horrified, and she actually brought an invasion of privacy lawsuit um, against the hospital that had facilitated this kind of photography, and her lawsuit was allowed to proceed on the theory not so much of the baby's privacy, but her privacy was violated by the publication of, well, the creation of these photographs, and then the dissemination of the photograph, even just to her. And it turns out that this case is part of a line of U.S. cases in which deceased infants and embryos or are photographed, and the photographs disseminated. So this case is going way back to the beginning of the 20th century, where in one instance, a child born with their heart outside their body was photographed without the parents' permission, and that was a source of a privacy lawsuit. And then there's another case in which conjoined twins were photographed with the permission of the parents for their own use, but the photographer decided to make extra copies for his own use, and that was the basis of a lawsuit that was won by the parents. So I'd love to talk about cases like that where there is some violation of an interest, it seems, but should we be focusing on the embryo or the fetus or the baby, or should we be focusing on the parents and family that are the relational living? It's not clear to me what the focus should be, but our argument in our paper is let's focus on the relational living. And then maybe just one more example would be good to think about a little bit. Kind of a common example. Um, Autopsy photographs. So autopsy photographs are often made for official governmental purposes. Someone dies, the death is mysterious, And then the question becomes, well, who gets to see the photographs? Is it just, can anyone see? Can they be put in the newspaper? Can you go down to the autopsy site and ask, as a member of the press, the media, to see the photographs? Who has access, should have access to autopsy photographs or to death scene images that are taken in relation to a possible homicide? And there's a famous case in the U.S. Concerning a man named Vince Foster, who worked for the White House, and he committed suicide, it turns out. But his autopsy pictures were of great interest to the press, the media. They wanted the pictures, and the question became, can the family stop the media from getting their hands on the photographs? And that was a topic that I think we still struggle with today, when there are governmentally entwined functions or purposes of death images. Should postmortem rights still bias heavily in favor of only allowing those people whom the next of kin would wish to see the images to see them? In the context of the public interest in postmortem rights, we briefly mentioned the possibility that sometimes, what people want for their death shouldn't govern what happens to their bodies. So, if, as happened in a recent U.S. case, a Jewish woman wanted to be buried in Israel and had purchased a plot in Israel for her birth, for her burial, but her relatives wanted her to be buried in New York or New Jersey, should her expressed desire to be buried in Israel govern, or should the family's desire to have her buried in the U.S. govern? And the court, it ended up in court because the family disagreed, and the judge ended up saying that, well, her express wish was to be buried in Israel. It was a reasonable wish. She bought the plot. She paid for it. Her body must be sent to Israel. But what about if somebody self-immolates? Some people burn themselves alive in public places in order to make a political point. And their desire is that their death be widely publicized, that these gruesome images of them in flames be widely publicized. Does the fact that someone wants their death image to be widely publicized, that they want to be a charred corpse laying in a public square, should that govern what happens to them post-mortem? So I think that kind of example shows that, although we're very tempted to say that, in simplistically to say that, oh, it's what the dead person wants that should govern how they're treated, I think the case of self-immolation raises an interesting a puzzle for whether or not preferences should be the basis of how we deal with the post-mortem privacy interests. So, is it past our future, where we have to have this hard conversation and decide? Thanks.